Hello YouTube, I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. Excuse me. We got a question here from Gary Spence, YouTube user Gary Spence, who says, "Good afternoon, Mr. White. Call me Vin, by all means. A disability claim here. After termination, I had to go before the unemployment hearing in front of a judge that ruled in my favor. It was stated in open court from the company HR manager that after I responded in an email to termination, that I'd be contacting the DOL and the EEOC for protection, as I believe it was pretext for termination. The judge ruled that it was not threatening per the defense. They admitted in open court that they didn't interview me for my discrimination claims, rather separated me for threatening to contact the DOL and EEOC. Never had a bad performance review. Well over 100 people at the company can attest I was targeted for FMLA usage. Is this a strong case in your mind with minimal information given?" Okay, so I don't usually do hypothetical cases. I guess this is not hypothetical for you, but it's hypothetical for us because we're not aware of the details. But let's dig into this one. So you're saying you have about 100 people who say you were targeted for FMLA usage. Sounds like that FMLA claim is strong. Now, it seems like you're also talking here about a retaliation claim, right? You're saying, and I'll read what you wrote. It was stated in open court by the company HR manager that after I responded in an email to termination, that I'd be contacting the DOL and the EEOC for protection, as I believed it was a pretext for termination. Later on, you say that they separated me for threatening to contact the DOL and the EEOC. If you didn't threaten until they fired you, then they can't separate you for threatening, right? We have a linear timeline. One thing has to happen, and you've said that they fired you first. If I understand what you wrote, and I might be misreading it, and I apologize if I am. But it seems like you're saying they fired you, and in response to them firing you, you said you were going to go talk to the DOL and the EEOC. That can't be a retaliation claim because unless you engage in some other protected activity. But the only protected activity you're sharing here is that after they fired you over here, right? And then sometime in response, you said, "I'm going to talk to the EEOC and the DOL." This came first where they fired you. Therefore, they can't fire you because you complained, right? They can't fire you because you complained if they fire you before you complained. Something that happens after an event cannot be the cause of the event in a linear timeline. Now, which is presumably the one we all live in, unless you are really pushing the bounds of existence with some sort of mushroom or LSD experience. I don't know. I don't know what you're up to. It's the only possibility for a non-linear timeline that I'm aware of for humanity. There might be other forms of life that don't exist on a linear timeline. Perhaps time, as physicists tell us, is not only traveling in one direction. Perhaps. But as far as I'm aware, we, cognitively, are only capable of a linear timeline. So if I'm reading your message correctly, your comment correctly, they fired you, then you complained. Therefore, your complaint cannot be the reason they fired you. Then, your complaint or your threat to complain would likely not be viewed as the motivating cause, protected activity that was the impetus for the termination because it hadn't happened yet. So, if I'm reading that correctly, then your termination would not be retaliation. That retaliation claim in just the events we're describing here I don't know if you engage in other protected activity. I don't know if something else happened. I don't know the specifics. But just the events we have here would be DOA, dead on arrival, going nowhere, that retaliation claim. Now, it does not mean that I'm positive that that's what happened, because you later say they separated you for threatening to contact the DOL and the EEOC. Maybe you threatened to contact the DOL, Department of Labor, and the Equal Employment Opportunity Commission repeatedly. Maybe you did it before and after they fired you. If you did it before they fired you, I would say you have a very strong argument that you engaged in protected activity at that point. And if they fired you after that, you've got a good temporal proximity there. You can really argue that the termination was a pretext. Termination was done on a pretext, and it was in actuality meant to retaliate against you for threatening to report them to the Department of Labor and the EEOC. None of this impacts the FMLA case, the Family Medical Leave Act case, which stands alone, right? If you were fired for using the Family Medical Leave Act, or if you were given a hard time or targeted for using the Family Medical Leave Act, that case is in and of itself a viable claim that can win irrespective of how the discrimination or retaliation or any other case is doing. So, when you ask me if it's a strong case, I don't know, because I don't know the timeline of events. I don't know a lot of specifics. I can say what you're telling me is the FMLA case sounds strong because you have many witnesses. You feel strongly you can prove it. And it resulted in termination, so that would theoretically be a good case, a strong case, a valuable case. And then in terms of that retaliation case, listen, if you threaten to go to the Department of Labor and the Equal Employment Opportunity Commission, presumably complaining of some form of discrimination to the EEOC, although do be clear about that, and then as a result you were terminated on some silly made-up pretext, yes, that is a great retaliation claim. I think you'll get offers from every firm you speak to. Overall, if that is a series of events, if that's what happened, it sounds like quite a strong claim. If it is they terminated you and then you complained or said you were going to complain, that is a junk retaliation claim. That is probably non-viable unless there's something else going on. All right? Now, your question, very savvy, says, is this a strong case in your mind with minimal information given? That's what I answered. That's why I answered, right? There's minimal information. You understand there's minimal information. I don't know what evidence you have. I don't know what kind of witnesses you're bringing. I don't know what your witnesses are going to stand up to. I don't know what they're going to say, right? So I can't tell you strong, not strong, solid, big time money. I don't know, right? I don't know. But I want to talk through it because I did see you said it two different ways, and we need to button that up, right? We need to figure out which it was and then never say the other way again if you're going forward with this, right? That's one of my key points. You got to get the timeline correct, and you got to be really accurate in how you communicate it, and communicate it with intentionality and with accuracy at all times. All right. I hope this was helpful. If it was, like, subscribe, comment down below, share our channel so it can grow. Take care, everybody.